Might be wrong. Depends on what number you
Okay. Jefferson County Court at Law number 2 is in session. The court is in session with its trial docket. We have cause number M330398, case of South State of Texas versus Willie Ray Guidry. Mr. Guidry is here with his attorney, Attorney Langston Adams. Next case we have is M330658, case of South State of Texas versus Cody Clinton Williams. And Mr. Williams is here with his attorney, Attorney Giles Cole. We have cause number M331985, case of South State of Texas versus Manuel Sanchez Oliva. Manuel Sanchez Oliva is not here. Mr. Oliva's name was called by the bailiff at the courthouse door at about 1:30. The time now is, and there was no answer, the time now is 1:49 p.m. on today's date of April 21st, 2025. Ms. Bailiff, would you please call the name of Manuel Sanchez Oliva at the courthouse door?
Yes.
Manuel Sanchez Oliva. Manuel Sanchez Oliva.
Manuel Sanchez Oliva. No response, John.
Okay, it's I think you said Olivia, it's Oliva. Manuel Sanchez Oliva. Yeah. Oliva.
Manuel Sanchez Oliva.
She still did it?
Yeah,
That's close enough.
No response, John.
that's not close, it's not, that's not horseshoes and grenades.
Oh,
And so you said Olivia, it's Oliva. Would you please call the name of Manuel Sanchez Oliva?
No response, John.
Okay, Manuel Sanchez Oliva's name was just called again at the courthouse door. He did not answer. Reasonable time has passed to give Mr. Oliva an opportunity to appear in court. He is not appearing in court. State, you have a motion?
Same moves for bond forfeiture.
That motion will be granted. Manuel Sanchez Oliva bond will be forfeited and warrant should be issued for his arrest in cause number M331985. Next case. Let's see, we have Albert Dwayne Gilliam, who's present in court with his attorney, Mr. Kimler. We also have Chelsea Nicole Petaway. She's present in court with her attorney, Attorney Wright Kimler as well. Next case is cause number 24 CCCR 2154. Case of Style of State of Texas versus Jason Allen Seward. Mr. Seward is present in court with his attorney, Mr. Kimler. Mr. Kimler. And so at this time, first case that we're proceeding on is Cody Clinton Williams. And Mr. Cody Clinton Williams is represented by his attorney, Attorney Giles Cole. Attorney Cole, are you ready?
I'm ready now.
And state, are you ready?
State's ready, Your Honor.
Okay. Now, we can give each side 30 minutes for the Vadar. I will have to conduct the impaneling before we start Vadar. And let's see, let me get this in here. Ms. Bailiff, you can bring in the panel. Ms. Garrett, would you please step to that first row behind the wall and go all the way to the end? That's the first chair. And Ms. Goff, you can follow Ms. Garrett, sit next to Mr. Garrett. Is that, oh, you know what? I wanted 3 showed up.
I don't believe 3 did, Your Honor.
Holloway,
Is that Miss Marabella? Okay, you're gonna keep a chair in between you and Miss Hill.
Yes.
Holloway, you're gonna sit next to Miss Marabella. And we're gonna have somebody missing. Holloway, yeah. Next one should be Kiker. Okay, Mr. Kiker, you're gonna sit on that first row. There's a chair in between you and Mr. Holloway. Jackson, you're gonna sit on that first row, that first chair on the end. And Calhoun, Mr. Calhoun, you're gonna sit next to Miss Jackson. Mr. Smith, you're gonna sit next to Mr. Calhoun. Mr. Alvarez Mendoza, you're gonna sit next to Mr. Smith on that first row. Sit next to him. Ms. Slater, you're gonna sit next to Mr. Alvarez Mendoza. And Ms. Blaine, you're gonna sit next to Ms. Sladen. Mr. Broussard, you're gonna sit next to Ms. Blaine, first row. Mr. Pataglia, but then that second row, you're gonna walk all the way to the end, all the way on the first set of chairs, and you're gonna sit next to Mr. Pataglia and Mr. Ward. Ms. Cashmere, you're gonna sit next to Mr. Ward on that second row. Is that Hebert?
Yes.
Mr. Hebert, you're gonna sit next to Ms. Cashmere. And Venegas, you're gonna sit next to Mr. Hebert. All the way over here, all the way over there. And then Mr. Carville, you're gonna sit next to Ms. Venegas. Three and 6 here. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this afternoon for a criminal case. You have been asked to come and serve as a juror on a misdemeanor criminal cases. Criminal cases are divided into felonies and misdemeanors. Felony cases are normally referred to as your more serious type offenses. They are handled in the district court. And the misdemeanor cases are normally referred to as your petty offense. It does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted in the case. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail. Person and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of capital murder, which is the highest felony, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. We don't handle those type cases. The cases we handle are misdemeanor cases. Misdemeanor cases are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, then the range of punishment is by fine only. And the fine cannot exceed $500. Class C felonies do not originate or do not start in this court. They start in the JP court or the city court. And then if a person is found guilty in one of those courts for the Class C misdemeanor offense, then the case, and if they appeal the case, then the case comes here. The range of punishment does not change, it's still the same. And the range of punishment is, as I mentioned to you earlier, is by fine only, and the fine cannot exceed $500. And those type of offenses will be like a traffic offense, not having your seatbelt on, having expired inspection sticker. Now, the next highest misdemeanor is a Class B misdemeanor, and the range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. Now, the highest misdemeanor is a Class A misdemeanor. If a person is convicted of a Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, as I mentioned to you earlier, you were asked to come here to serve as a juror in a misdemeanor case. And our court hours are normally from 9 a.m. to 5 p.m. However, in County Court at Law Number 2, in the morning, we have several dockets, and we usually don't get out of court until either 12, sometimes after 12. And so we have our trials in the afternoons, starting at 1:30. Now, whether you're selected as a juror or not today, in this case, you're performing a significant service which only free people can perform. If you're selected, this case will be tried expeditiously, consistent with justice, which require a careful and correct trial. Now, I must administer to you the first of 2 administrative duties. And I need everyone to raise your hand. I need to give you an oath. And then once I finish giving you the oath, please say, I do. Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions, touching your service and qualifications as a juror, so help you God? Okay, you may put your hands down. Now, ladies and gentlemen of the panel, the law requires that each of you must possess certain qualifications before you may be considered as a juror in a criminal case or in a case, period. Also, there are certain excuses and exemptions some of you may wish to claim. I will first determine if all of you possess the qualifications to serve on a criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you are seated on a jury, the case could be retried and you may be held in contempt of court and placed in jail for up to 180 days and fined up to $500. Now, the way I'm going to ask the questions, I will ask a series of questions. And then I do not want you to answer the questions out aloud. I just want you to answer those questions to yourself. And when I get to the last question, or when I'm gonna ask the last question, and actually the last question will be, is anyone disqualified under the law? And if you think that you may be disqualified under the law, I would ask that you just raise your hand, your right hand, and then we will discuss the matter outside of the presence of the jury in a manner that is more private. And when I say outside the presence of the jury, what I'm talking about, first of all, we have YouTube on. The YouTube would be turned off. We would turn off the microphone. And then we have a noise sound device that we will play so that no one else in the panel will be able to hear the discussion. Okay. Does anyone have any questions before I proceed? Okay. First question. Except for failure to register, are you a qualified voter in Jefferson County and the state of Texas under the Constitution and laws of the state of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I usually pause at this next question because I need to inform you that this question I'm required to ask by law. I'm not trying to pry into your personal affairs. And the question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 3 months in a county court or 6 days in the preceding 6 months in a district court? And that was the last question. Now, is there anyone disqualified under the law? If you think that you may be disqualified, please raise your right hand. Okay, we have 2 people, juror number 7 and juror number 18. Okay. Mr. Cole and prosecutor, y'all come up. Is there anyone else who think that they may be disqualified under the law? Okay, let the record reflect that, all the jurors are qualified. And now we will move to the next set of questions. Now, I will, determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror in this case, just continue to remain seated. Now, I'm going to ask these questions in the same manner that I asked the last set of questions. I'm going to ask a series of questions, and I would ask that you would just answer those questions to yourself. And then once I finish, I'll ask you if there's anyone who would like to claim one of the exemptions. Now, the first question. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12 years, and jury service would necessitate leaving the child or children without adequate supervision? Or you're a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in the county in this county during the past 3 years before today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of the United States military forces, serving on active duty and deployed to a location away from Jefferson County? Now, is there anyone on the panel who would like to claim one of the exemptions? If you would like to claim an exemption, please raise your right hand. Let the record reflect that no one on the panel is claiming an exemption. We will now move to excuses. And with the excuses, I will not ask you any questions. I will make 3 statements. And if you would like to claim an excuse based on any one of these statements, when I ask if anyone would like to claim an excuse, just please raise your right hand. A juror may be excused for observance of a religious holiday upon the completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties, that is, without the consent of the defense and without the consent of the state. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who would like to claim an excuse? Let the record reflect that no one on the panel is claiming an excuse. All members are qualified, and no one on the panel is claiming an exemption. Let the record reflect that The court is convened in this case at 2:17 PM on today's date of April 21st, 2025, in County Court at Law Number 2, Jefferson County, Texas. Judge Terrence Holmes presiding. The case that is before us is the state of Texas versus Cody Clinton Williams. The defendant counsel and counsel for the defendant, counsel for the state, and all members of the jury panel are present. Again, ladies and gentlemen, good afternoon. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law Number 2. And you have been summoned to this court as a prospective juror in this case, cause number M330658. The defendant, as I mentioned to you earlier, is Mr. Cody Clinton Williams. He's sitting at the table as to your left, the gray coat on. He is represented by his attorney, Attorney Giles Cole. The state is represented in this case by Assistant Criminal District Attorneys, Attorney Haley Simmons, who is sitting first chair, and Attorney Kyle Glasper,
Good afternoon.
who's sitting second chair. The court reporter, who's sitting to my left, some of you may be able to see her, some of you may not be able to see her, but this Miss Ada Christie, she will be taking down everything that is being said. So speak up when you're asking, when you're answering questions, or when you're asking questions. The bailiff is Miss Brenda Mosby. You met her earlier. The defendants stand charged by information with the offense of driving while intoxicated. In this case, it is a Class B misdemeanor. The state and the defendant, through their attorneys, have the right to question you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up before the bench so that we may discuss the matter more privately. State, are you ready? Defense, are you ready?
We're ready, y'all.
Okay. And we'll give each side 30 minutes. Is that enough time or you need more time? Enough time? Okay. The panel is yours, Ms. Gass.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. Judge Holmes mentioned, my name is Kyle Gasper, and I'm sitting with Assistant District Attorney Haley Simmons. We are excited to present this case and get to talk to y'all and to know y'all a little bit better. Before we really get started and talk about some questions that I have for y'all, does anyone know either any of the prosecutors or the defense attorney or the defendant? Does anyone know any of the people in this room? Anyone know the judge or the bailiff? Anything? All right, we're good to go. So I work for the prosecutor's office. We represent the state and we represent the people of this county. That means that we are going to put on this case. We're going to have some questions for you today to try to get to know you a little bit better, to see if you might be a good fit for this case. We just really want to get to know you and keep this organic and painless as possible. I'm sure everybody was just counting down the hours until they got to be here today for jury duty, thinking about it all weekend. I know how exciting it is to be on the misdemeanor jury panel on Monday afternoon. But we thank you for being here. We wouldn't be able to do our jobs without you. So, as Judge mentioned, see if we can get this to work. There we go. As Judge mentioned, this is going to be a DWI. Under the Texas Penal Code, a DWI is if a person is intoxicated while operating a motor vehicle in a public place. Now, who has seen someone who's been drinking, who's been drunk? Has anyone witnessed a drunk person? Yes. We have a few hands. I saw you first, Mr. Smith. You describe to me kind of what happens when someone's drunk.
It's on person. Some of them get real happy and some of them get mean. You know, but they basically lose motor controls and tend to stumble around a lot.
Thank you, Mr. Smith. And I just ask in general, you did a great job being loud, but I do ask that if I do call on you, speak up so that our court reporter can get down everything that you're saying. But yes, they can, it depends on the person, depends on several factors about that person, but there's many ways to see if someone is intoxicated. Can we all agree that intoxication looks different? He did a good job stating that some people are happy, some people are mean, some people, everyone's a little different when they are intoxicated. So a person commits this offense if they are intoxicated, and we're gonna go a little bit more into depth on what it means to be intoxicated under Texas law. So you can be intoxicated by not having the normal use of your mental faculties by introduction of alcohol into the body. You can be intoxicated by not having normal use of your physical faculties by reason of introduction of alcohol into the body, or you can have a blood alcohol or alcohol concentration of 0.08 or higher. Now, do you think you have to have all three of those at one time to be intoxicated? No. Juror number 5, Mr. Holliday. Holloway, I apologize, that's on me. Do you think you need to have 1, 2, or 3 of those to be considered intoxicated?
It's 4 statements, so the beginning,
Yes, thank you. Mr. Holloway is correct. You only have to have 1 of these 3, as he said, an or statement, be considered intoxicated under Texas law. And like juror number 10 said, Mr. Smith earlier, intoxication can look different on different people. Intoxication can look different in different ways. You can have loss of your mental faculties. Can someone give me an example of what it might be to lose a mental faculty? Anyone have an idea of what that might look like? I'm sorry?
Slurring of speech.
Slurring of speech? Yes, thank you, Mr. Smith. I appreciate you speaking up. If I don't have people speak up, I will start calling on y'all. So I want to keep this as conversational as we can, but I do encourage y'all to speak up. Also encourage y'all if you have any questions or you're confused about anything, please raise your hand. I want to make sure that everybody's on the same page and understands what we're talking about. So if you have any questions, feel free to holler at me. So slurred speech is a loss of a mental faculty. What about a loss of a physical faculty? Anyone have an idea of what that might look like? Stumbling, yes. Thank you. Juror number 7, Mr. Kiger. And I believe Ms. Goff, you said that as well. Stumbling, moving around kind of slow, loss of physical faculties. And obviously, if your alcohol concentration is of a 0.08 or higher, which is not something you can see with the visible eye, but there's ways. So I just want to reiterate that as part of proving that someone was intoxicated, we only have to prove 1 of the 3. There can be more, but the state law requires us to prove it. Now I want to talk a little bit about why we're here, why we prosecute these types of cases, why we take time in our schedules and we work up these cases and we prosecute them. Why do you think that it's important to prosecute a driving while intoxicated? Yes, juror number 18, Mr. Hebert.
Keep them off the street.
Yes. Thank you, Mr. Hebert. To keep them off the street. Does anyone have any other reasons that we might prosecuted. Yes, juror number 13, Ms. Lane, discourage others, or helping me do my job. These are exactly the answers that I was looking for. So, with public safety, we want to keep them off the streets. Deterrence. Did y'all see my PowerPoint ahead of time? Y'all are hitting the nail on the head. We also want to hold people accountable. Make sure that people realize that this is wrong, this is against the law, and like y'all said, to safety, to keep people from doing it again. There are serious consequences to these types of things, and we want to make sure that that is avoided. At this time, I do want to talk a little bit about the prevalence of DWIs in our community. It's hard, it's something that we do deal with a lot, and I just want to know, has anyone been a victim of a DWI or know someone that was a victim of a DWI crash? Juror number 8, Ms. Jackson, I do want to, before you speak, I'm sorry, I do want to let you know if it is too personal to talk about, you're more than welcome to talk with us after everyone's outside, if that's, no, okay, what happened to you?
My nephew was killed by about 20 years ago.
I'm very sorry to hear that. I apologize for I'm sorry for your loss, I apologize if that happened to you. Would that experience that you went through with that, would that prevent you from being fair and impartial in hearing this case? Thank you, Ms. Jackson, I appreciate you for sharing that. Does anyone else? Yes, juror number 17, Ms. Kathleen?
I had a cousin that was killed at 9 years old by a drunk driver, and another cousin at 31 of them went off from his college graduation.
I'm very sorry to hear about that. I'm sorry for your loss, and I'm sorry that that's something you have to go through. Would those experiences keep you from being fair and impartial in this case? Thank you. I appreciate you sharing. I saw another hand over here. Yes, Mr. Jackson, juror number 8. Or Mr. Calhoun, juror number 9.
My sister and her children were severely injured by a driver who had 7 intoxication warrants against him and was drunk at the time.
I'm very sorry to hear about that. Would that prevent you from being fair and impartial in this case? I appreciate you all for sharing. Oh, yes, juror number 16, Mr. Ward.
My daughter said had on by a drunk driver.
I'm very sorry to hear about that. Would that prevent you from being fair and impartial in this type of case? Yes. We might want to speak to you. Thank you for sharing. I mean, it's not an easy thing to talk about, but I appreciate y'all being honest and open with me. Makes my job easier going forward, and I apologize for all of those that have been hurt and felt pain for this type of offense happening to someone that's going to. So before I move forward, what types of evidence would you like to see in a DWI trial? You're picked for this jury and you're sitting over there in that box. What type of evidence would you want to see? Yes, juror number 1, Ms. Gator.
Oh, like video.
Video.
Yeah, from the officers.
Okay. Anybody else? What other types of?
Positive blood alcohol.
Okay, yes, y'all both agree on that one. That's juror number 5 and juror number 7. Anything else anyone would want to see? History, all right.
Hang out, the accountability of how many times
Mhm.
person.
Yes, definitely, juror number 17 and 18. Those are good points to bring up. Going off of evidence, what type of witnesses would you might want to hear in this type of case? Who would you want to hear from on that witness? There? Officers, juror number 2. Anybody else? Witnesses, someone that might have seen it. Juror number 8, Ms. Jackson. If I repeat your number or anything, it's just so that the record is clear for later on. I'm not trying to forget your name or anything like that. It's just trying to make it as clear as possible for our. So we want to hear from officers, we want to hear from witnesses, anybody else we might want to hear from.
I'd say like character witnesses as well on the opposite end.
Okay, so the witnesses. Thank you, juror number 1. So do you think, after hearing from these types of witnesses, any of the types of witnesses that you might hear if you do get picked on this jury, do you think that different types of witnesses should be held to the same or different level of credibility?
I think that's a tricky question. It would, I mean, I take everything all together, as a whole, and then,
Yes.
so that, I couldn't answer that one way or another.
I think that was a great answer, juror number one, thank you. We do, when someone is on the stand, they're not given more credibility based on their profession or anything like that, or less credibility based on everything. Everyone is held to the same level of credibility when they get on the stand. Would you be able to hold everybody to the same level of credibility?
Oh, absolutely.
Absolutely, yes. Thank you, juror number one, Ms. Gayer. That was a good way to bring it all together and look at the whole picture, because that is exactly what we are asking y'all to do in these types of cases. So I'm gonna go back a little bit to why we prosecute. We talked about that. We had some good answers come up. I do want to get rapid fire, just a little bit more of an understanding of where y'all stand on why we prosecute these types of cases. So what I'm gonna do is we're gonna go through these, and I'm gonna ask you rapid fire how important you think it is to prosecute these types of cases. And all I want you to answer is number one, it's not important. Number two, somewhat important. Or number three, it's very important. I'm just gonna go down the list to give me kind of a better understanding of where y'all stand on these types of cases. And we're gonna move forward through this. And if you kind of forget the scale or whatever, it's up there for your reference. So juror number one, what number would you say?
Oh, very important.
Okay, thank you. Juror number two? Juror number four? Number three? Juror number five?
3.
Juror number seven?
3.
Juror number eight? Juror number 9?
3.
Juror number 10?
3.
Juror number 11? Juror number 12?
3.
Juror number 13?
3.
Juror number 14?
3.
Juror number 15?
3.
Juror number 16? Juror number 17?
3.
Juror number 18?
3.
Juror number 19? 3. And juror number 20.
3.
Thank you. That was easy. So now moving on, the defendant has several rights when we come into a court. Y'all have the same rights. If you were to be sitting in this chair, everybody has the same rights under the Constitution, and I just want to speak on them a little bit. So first off, the defendant does not have the burden of proof. The defendant doesn't have to prove anything. He is presumed innocent unless proven guilty. That's what you get, that's what I get, that's what everybody gets under the Constitution. He does not have to put on any case, he does not have to testify. It is the state's burden to prove our case. It's the state's burden to prove all of the elements of intoxication, all of the elements of a driving while intoxicated charge that we talked about earlier. That's on us. We have to put on the case, we have to make that burden of proof, and the defendant does not have to do that. That is his right as a defendant, it's everybody's right in this country. You also have the right to discovery, that is the right to see the evidence in the case. You have the right to a trial, which is why we're here. Everyone that is accused of a crime is given the right to select to have a trial by jury. Trial by jury, that's why we're here today. The defendant also has the right not to testify. The defendant does not have to take the stand. You do not have to hear from the defendant. And that is his right. That's not something that you can hold against him. He does not have to say anything because we have the burden. He doesn't have to prove his innocence. He's presumed innocent. If the defendant would choose not to take the stand and choose not to have the right not to testify, would any of y'all hold that against him in this case? Anybody have any issues with that? No? You raising your hand or just?
Gotcha.
Okay, just confirming, juror number 16, thank you. You also have the right to defenses. You can put on defense can put on a defense if they would like, but they do not have to. They do not have to put on a case in order to be found innocent because they are presumed innocent. That does not go away the second we start a trial. They don't have to put on a case, but they can. They can put on defenses should they like to. Okay. However, in this type of case, the defendant does not have a constitutional right to refuse a sample of blood or breath when arrested for suspicion of a DWI. This is because driving is a privilege. Driving is not something that is a constitutional right. You do not have to drive a car. You choose to drive a car, it is a privilege to drive a car. And by choosing to drive a car, you're choosing to follow the laws. And if you are under suspicion of breaking one of those laws, you don't have the right to refuse. However, you can refuse, and there's just consequences to doing so. you have the implied consent when you get on the road that you're to follow the law, you're to follow the laws of the road, and if not, there are consequences. For example, you can refuse to give a sample of your blood, you can refuse to give a sample of your breath. I'm sure you've seen the defense billboards saying that you should refuse that. You can, that's absolutely something you can do, but there are consequences to that. It's not a constitutional right like we just talked about before, where that's not something that you can consider. You can lose your license for a period of time by refusal. That's something that the DPS does. It's part of what happens. It's the consequence to choosing to refuse to give a sample. It can also be evidence that you may hear at trial and be considered by the jury. I want to contrast this to what I said before about the defendant doesn't have to testify, he has a right not to testify. That's different. That cannot be held against him. That cannot be considered against him. This is different because you do not have a constitutional right to refuse a sample. Does everyone understand the difference? Does that make sense to everybody? Does anyone have any questions or concerns on that? Is anyone not like that? Does that not sit well with anyone? If it doesn't, we want to hear about it now so we can discuss it. We don't want you to get picked and be back in the jury room. I don't think I can fully understand that or follow along. Does anyone have any concerns about that before we move forward? No? Okay. So I mentioned the burden of proof earlier. Has anyone heard what the burden of proof is? We've heard those words, know what that means, anything like that? Jury number 14, I'm gonna pick on you, I know you're an
Sure.
attorney. Could you explain to everybody what the burden of proof is?
The burden of proof would be, your responsibility to bring the facts of the case forward to show that an offense has or hasn't occurred.
That was perfect, thank you. Did everyone hear what he said? It's our responsibility to bring the facts forward to show that something did or did not happen. That was a fabulous explanation. I appreciate that during number 14. So we talked about how there's the presumption of innocence, which means the defendant is innocent unless proven guilty. I'm sure you've heard that saying before. I'm sure you've heard a little bit of a variation on that. But it is unless proven guilty. That doesn't mean that until proven guilty, we have to meet our case for you to find him guilty. And if we don't meet our case, then he's not guilty. And we have that burden. That burden never shifts to the other side. We have to put on a case. And we must prove the defendant guilty beyond a reasonable doubt. That is the burden that we have to hit in these types of cases. There's a different burden in different types of cases. Civil cases, burdens are a little different. Family law cases, the burden is a little different. But in a criminal case in Texas, the burden is beyond a reasonable doubt. Now, anyone know what that means? Beyond a reasonable doubt. Anyone have an idea of what that means? Yes, jury number 14, Mr. Broussard.
If I remember correctly, it's more likely than not.
So we actually cannot give a definition. The state legislature says that we cannot define it. It's up to every single one of you to decide what beyond a reasonable doubt means to you. Now that's not beyond a shadow of a doubt. It's not beyond all doubt, beyond a reasonable doubt. The best way that I can describe it is you'll know it when you see it. An analogy I like to use at this part is a puzzle. When you're working on a puzzle, you might be putting together the puzzle. Has everyone done a puzzle in here? Anyone not know? Okay. So when you're putting together a puzzle, you're putting together the pieces and slowly the picture's coming together. Do you have to put together the entire puzzle to know what that picture is going to be? Do you have to put it together every single piece to be able to see the picture come together? No. Juror number 17. You don't have to put the whole picture together. You have to get to a point though to see what it's going to be. You can't just put two pieces together and on the corner and be like, oh, I know what that picture is going to be. You have to have a little bit more than that. But you can have some pieces missing to be able to see the full picture of what it's going to be. And I like to use that because it shows that the whole puzzle, all of the puzzle pieces might not be there. But it's up to you to determine when you can see that whole picture, even with some of the pieces missing. Again, you'll know it when you see it. And it's up to each of you. In your heart of hearts, did the state meet their burden beyond a reasonable doubt? I can't define it for you. It's up to your interpretation, and that's why we don't give a definition, because everybody's different. Everybody in this room has different experiences, different situations. We want you to be able to use what you know, your common sense. And I know you all have common sense. You drove here today, you signed in a jury duty, you're sitting here and conversing with me. We all have it, we can use it, and you all have to each come to the decision of what that means to you and be able to apply it to the facts in this case. And find whether or not the state has met their burden of beyond a reasonable doubt. Can everybody do that? Does anyone have any issues with doing that? Would you need a definition to be able to do something, to find beyond a reasonable doubt? You have any issues with that? I just want to say again, I appreciate y'all being here. I know it's after a holiday weekend, everybody's tired, trying to get back to the swing of things. It's a Monday. But we can't do our job without you, and it's called jury duty for a reason. Y'all have a duty as citizens of this county. You have a duty to decide the facts. You have the duty to apply the facts to the law, and you have a duty to follow the law. And we cannot complete our jobs, and we cannot go through these trials without people like you showing up and helping us, and ultimately being the fact finders in these types of cases. So I appreciate you being here. You will get to hear from me later on. If you are picked on this jury, you will get to hear from my colleague Haley Simmons as well. We are looking forward to presenting the case to some of you, and I appreciate you all being here today.
Let's go.
Well, my name is Giles Cole, and it's going fast, and since I'm going to be asking you a few questions, and I'll tell you a little bit about myself. Okay. I'm from Orange, Texas. I have a brother and sister and 2 kids. One's 21 and one's 7, so of course I post-traumatic stress with the first one. My younger daughter coming. How many of you in there? If you hear one of your kids crying, do you run into the room and spank the kid that isn't crying? Or do you wait and hear both sides of the story? What do you think is the right thing? What is it? Sides. That's what I was supposed to do today. Is that fact? Or we agree with both sides of the story? Well, I have the privilege of representing Mr. Williams. And that's because only one side of the story has been told. Unlike felony cases, these cases right here don't get a chance to go through the grand jury, so there's not a real vetting process. And so we're here, and you're gonna hear their side. But our side is that Mr. Williams was not driving his motor vehicle while he was under the influence of alcohol. Okay. Now, I have a duty here as a defense attorney, and that is to vigorously defend my clients. And Ms. Garrett, could you give me an example of how an attorney would vigorously defend his client?
Well, you look at all the facts of the case, you would hear your person's side, and you would represent them in the best way you can, based on what you know.
That involves maybe questioning police, is that accurate?
Yeah, everybody should be questioning them.
Does that mean I have to be nice to people that I'm questioning?
I think you should be nice as a human.
I agree with you, and I'm a nice guy.
Okay.
I'm a nice guy. Yeah, I'm not gonna be mean with them, but you know, maybe sometimes I might have to poke and prod a little bit to get to where I gotta go. Not mean, just saying. All right. You know, we're all humans and we have strong feelings about things. For those of you that lost loved ones to either drive, Ms. Broussard, Mr. Smith, this past year. My job today is to make sure that all of our constitutional rights are protected. That's my job. To make sure that the state has done their job. Because any of us could be in this situation, right? And so, I hope you don't hold it against me if you're part of this jury that I have to protect constitutional rights. And I'm trying to keep the status quo. What we have going on in our great country. I love our country. So, love the Constitution. That's what we're doing. This is word here, whatever you want to call it. But that means to speak truth. Truth, that Mr. Williams here, is asked for you to sit in judgment of him. You are his peers. 6 of you are going to be his jury. I'm sorry, hold on, let me wrap. Got you, you'll get your time for it. So, sorry. Honorable Judge Holmes here. He's gonna chaperone this thing. He's the judge of the law. And you all will be the judge of the facts. And only 3 decisions that you can make. If he's guilty, he's not guilty, or you can't make your mind. That's it. The only 3 decisions that you can make. Now, I don't pick on you, Mr. I tell you, attorney. How many of you walked in here today thinking to yourself, why are we here? Any of you have some thoughts? Why are we here? What did he do?
We're here for a reason.
Here for a reason. Mr. Hebrew, you said you were thinking that, were you?
Yeah.
Okay. What about you, Mr. Ward? Not really? Ms. Marabella?
Just listening to the facts.
This is the facts. Okay. How many of you have heard of the presumption? What the term presumption? How many of you have heard that term? Mrs. Smith, what does presumption mean?
You assume that, something is, before whether you know it to be truthful or not.
That is totally correct. That means that you skipped from A to Z and you didn't get a chance to listen from B to Y. And there's only one presumption in a criminal case, and who can tell us what that is? It's yeah. Mr. Oh, I'm gonna get it right. I'm gonna get it right. Battalion. Right now, decide the case, guilty or innocent.
Can't do that.
Why is that?
Of all the facts.
No, wrong. Presumption is innocent. Yeah, I didn't mess with you there. We're presuming innocence here. Mr. Broussard, let's say my colleagues right here, they put on 10 witnesses and they get after my client here and they sit and they rest and it's our time to put on evidence and we don't do anything. What is the presumption? Guilty or innocent?
Presumption is the same.
I give that away to you. I gave that away.
Presumption is the same.
That's right. It doesn't matter. Folks, it's not until the jury, until this judge here instructs you, gives you your instructions, and you go back to the back, and you weigh up all that evidence that you come to conclude. Is that fair? Presumption is innocent. Now, kicker is this. They have to prove it all beyond a reasonable doubt. Beyond a reasonable doubt. Every bit of testimony, every witness that comes on that stand, every exhibit that you might see, you have to filter this through your brain, and you don't give it nothing unless it's beyond a reasonable doubt. That's what we're weighing up here. Yeah. there are all kind of analogies people like to use. You know, I went out there and see all kinds of UFOs and stuff they say, but how many of you believe that there's life on other planets? But have y'all seen the UFOs on Fox? And, you know, I mean, hey, we got stuff all in the sky, but have can we say that there's life on other planets yet? Beyond a reasonable doubt. I can't say it, but I'm skeptical. Might be some stuff out there, but I can't say that yet. So, all that information has to be beyond a reasonable doubt. They got to bring us ET. That's what we ask them to bring us ET, right? Get some picture of something flying in the sky. I want to see the alien. And I'll give you a way that you can think about this. Think about it like this. What is the most important things in your own matters? Family, kids, finances. Proof that is beyond a reasonable doubt should be so convincing that you would act upon it without hesitation. When dealing with your kids, when dealing with your faith, when dealing with your finances. And so that's the kind of strict scrutiny that we have right now with this, because this involves possible jail time. None of us know how much time we have left. We're all gambling with time, resource that we don't know how much we have. So whenever the state is talking about incarcerating somebody for doing something, they damn well better know beyond reasonable doubt or be able to prove it beyond reasonable doubt. Because here we're playing with life. I don't know what I do. If I did do it like this, innocent people could be prevented. Wasting a resource that they don't know how much they have left. So, that being said, I think my colleagues have covered mostly everything. Oh, I got a few more questions. How many of you drink alcohol? Scotch. Scotch, Mr. C.
Wild turkey and
Or turkey, Mr. Kicker. I like a good,
I do partake.
I like a good scotch every once in a while. Mr. Broussard, are you a scotch guy?
Scotch.
Yeah. I didn't start drinking scotch until I started practicing law. I wasn't a drinker. I was not a drinker. The office I'm at, hell, I walked back there and they had some little bitty glass with some scotch in it. I'm like, what's going on? Well, y'all were talking the law. So now I enjoy my scotch. The law allows us to drink. Okay? So is there anything wrong with having a few drinks and getting on the road? Anybody have a problem with that if you're not under the influence? Anybody? I think that's it. We're not going to waste any more of your time, folks. I appreciate all of you coming out. I look forward to presenting my side of the story. And I hope that y'all come back with a good verdict. Thank you for your time.
Okay, ladies and gentlemen of the panel, we're gonna ask that you go out into the hallway, go through any one of the two doors. And we will probably call some of you back in for some follow-up questions. So at this time, would everyone please stand as the panel exit the courtroom? You can exit either side. You may be seated. County Court Law number 3 is back in session. The court is in session in cause number M330658. The case is styled the state of Texas versus Cody Clinton Williams. Let the record reflect that Mr. Williams is present in court with his attorney, Attorney Giles Cole. Let the record also reflect that the state is present with Assistant District Attorneys, Attorney Haley Simmons and Attorney Kyle Gasper. Let the record reflect that the jury panel is now present and seated in the courtroom. Ladies and gentlemen of the panel, when your name is called, please go have a seat in the jury box. And we have Ms. Linda Segura, who is one of the court coordinators here. She's going to call your name, and when your name is called, there are some badges on the countertop of the jury box. You take a badge and have a seat, and you can pin the badge on you. At this time, Mr. Segura, would you please call the names?
Michelle Gayer,
Michelle Gare, would you please come forward?
Jennifer Goff,
Jennifer Goff.
Jordan Kiker,
Yes, grab one of the text. Jordan Kiker,
Patrick Calhoun,
Patrick Calhoun,
Richie Smith,
Richard Smith,
Veronica Sladen,
Veronica Sladen,
Angelique Casimir.
Angelique Cashmere. Please get a badge. And you can pin the badges on. Miss Wilson.
Yes.
Everyone, you can pin your badge on. Okay, ladies and gentlemen of the jury, at this time, I must administer to you the second of the two oaths that I previously mentioned. Will each one of you raise your right hand? Do each of you solemnly swear or affirm that in the case of the state of Texas versus Cody Clinton Williams, you will a true verdict render according to the law and the evidence, so help you God? Okay, you may put your hand down. Now, members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts come from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and court decisions interpreting them and how they may apply to this case. You and I have equal authority in this case, but it is divided authority. You are the sole judges of the law. Well, you're the sole judges of the facts, and I'm the sole judge of the law. You're the sole judges of the credibility of the witnesses and the weight to be given their testimony. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney of witnesses or objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there is a legal reason why the testimony or document or object should not be received by you. Sometimes I will sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can hear the discussion on the point of law. The reason for that, as I told you earlier, you are the sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate facts. Therefore, you can't be within hearing when I deliberate questions of the law. Now, the reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather all of her equipment and take it with her, and attorneys would have to gather their files, etc. The ruling I do make in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defense have rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. We will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and to make reasonable deductions from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of this case, nor attempt an independent investigation on your own. Don't visit the scene involved in the facts of this case. Don't read any reports in the newspaper, or watch television, or any information on social media about this case. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial, and don't visit courts during a break if a trial or other proceeding is in progress. Now, the badges that you have, you'll be allowed to take them home with you. Wear those badges at all times because those badges identify you as a juror in this case. Now, ladies and gentlemen of the panel, those of you who were not selected as a juror in this case, first of all, I would like to thank you for taking time out from your busy schedules to be here today. Now, I do know that when you came to jury duty today, you were expecting to serve as a juror, and you may feel that you wasted your time, but I can assure you, you did not waste your time. And the reason why I say that is because the fact that you made an appearance today helped us to move many cases. I mentioned to you earlier that we have our jury dockets in the morning, and our trial docket started actually this morning at 9 a.m. And at that time, we had with several cases on the docket. But when they realized that we had a jury coming in, sometimes, individuals, they say they want to go to trial. They have a right to go to trial. And sometimes some people think that they will go to trial because they believe one or two things is going to happen. Sometimes they believe that a jury is not going to show up, or they believe that the witnesses are not going to show up. But on days like today, when the jury shows up, witnesses show up, sometimes people have a change of heart. And they say to themselves, you know what, that offer that the state made to me a few months ago, it looks pretty good right now. And so it was because of people like you who take time out from your busy schedule. You help us to move the court's docket. And I would like to thank you for taking time out from your schedule to be here. Now, I know that when you came here this afternoon, you probably looked over the door and you said that, oh, this is county court at law number 2. This is Judge Holmes' court. Well, this is not my court. I'm only an humble public servant serving the citizens of Jefferson County. This is your court. And I've said that to say this. Anytime that you're in the area of county court at law number 2 of Jefferson County, you can come and have a seat in your court and see what's going on in Jefferson County. And I assure you, you'll find that is very interesting. Now, you can have a seat in an area that you're sitting in. We call that the peanut gallery. But it doesn't mean you could bring peanuts in here and eat, because this is not the Texas Roadhouse. And so you can come and have a seat in your courtroom and see what goes on. And if you need some coffee, we have a bailiff and court coordinators who make some pretty good coffee. And you can have a cup of coffee and just have a seat and see what goes on. Now, if you cannot make it to the courtroom, we're on YouTube. We have a YouTube channel. Just go to Jefferson County, Texas, County Court at Law number 2, and you can watch the trial. Now, this trial, actually, as I mentioned to you earlier, we start at 1:30 in the afternoons. And so this trial is going to pick up with testimony starting tomorrow at 1:30 in the afternoon. So if you in the area, you can come by if you're interested and seeing what's going on in this case. You can do that, or you can turn to our YouTube channel. Now, our bailiff have some letters for you. If you'd like to, drop a line or you read the letter, and you think that there's some other things that we can do to make it more convenient for you, just drop a line to us and we'll be happy to take your advice. Again, at this time, your jury services are concluded. Now, before you leave, I usually give everyone a handshake, and we still have COVID in our community. I give what I call an air handshake. So at this time, give everyone an air handshake, and thank you for coming here. And again, you are excused, and everyone have a blessed day. All right. Yes. You have enough. She has enough. I think she has enough. Okay, y'all may be seated. Okay, ladies and gentlemen of the jury, as I mentioned to the panel earlier, we will reconvene with this case on tomorrow at 1:30. And we need everyone to be here at 1:30. Make sure you have a seat right outside of the courtroom. And then when we're ready for you to come in, the bailiff is going to come and get you. You can bring the badges home with you. Make sure you wear the badges when you come back. So at this time, you are excused for the evening. Everyone, please stand as the jury exit the courtroom.
Yeah, yeah. Yeah, I got some more for him.
Yeah, I.
Okay. The court is recording the recess till 1:30 tomorrow.